Have you ever felt that exams are unfair? Maybe because some students have access to coaching, others don't. Some study in English medium, others in regional languages. Some belong to privileged backgrounds, while some belong to middle class family and the lower class backgrounds. And they struggle with even basic facilities. Now imagine in such a diverse country, who ensures that exam remain equal, fair and just for every student? The answer is simple but powerful. The answer is the Supreme Court of India. From UPSC to NEET exams, from JEE to judiciary exams, whenever student felt inequality, the Supreme Court stepped in using the Constitution to guarantee fairness. Stay with me till the end of this video because we are going to answer how the court uses Article 14, Article 15 and Article 21 to protect exam equality. The landmark judgments that change student rights forever and the challenges that still remains. And trust me, by the end, you will never look at exams the same way again. This is Ashish Jain, founder and chief educator at Doon Law Mentor, where we help law students crack judiciary and APO examinations in India. Let's start with the session. First of all, we will deal with the constitutional foundation. As far as constitutional foundation is concerned, first, let's go back to the basics. The Indian Constitution is not just about politics, it is about everyday life, including the exams. Three powerful provisions matter the most here. First is the Article 14 of the Indian Constitution, which provides the right to equality before the law. No student can be treated unequally without a reasonable basis. Another provision is Article 15 of the Constitution, which says that no discrimination based on religion, race, caste, sex or place of birth, including in exams and admissions. Another provision that is very, very important, Article 21, which provides right to life and personal liberty. This has been expanded to include the right to education, right to livelihood, and even the right to dignity. Together, these articles ensure that exams must be fair, transparent, and accessible to all the students. Before moving further, let me ask a very important question to you. Have you ever felt exams in India are unfair, maybe due to language barriers or reservation debates? Drop your thoughts in the comment section. I would love to hear your perspective. Now move on to the landmark judgment on that specific issue. As far as landmark judgments are concerned, let's see how the Supreme Court applied these articles in real cases. The first one is the Indra Sahane versus Union of India to 1992 Supreme Court. The famous Mandal Commission case. Here the court upheld reservation for other backward classes in education and the jobs. Reason why? Because equality does not mean treating unequals equally. It means removing the barrier so that everyone gets a fair chance. Another case is State of Tamil Nadu versus Union of India 2017, that is NEET case. There was a huge debate on whether NEET favors urban and English medium students over rural and state-based students, board students. The court held NEET as valid but emphasized the need for support students to ensure level playing field. Another judgment is Neil Aurelio Neumes versus Union of India 2022 NEET PG case. Here the court upheld the 27% OBC and 10% EWS reservation in all India quota seats. This affirmed that merit cannot be measured in isolation. Social and economic disadvantages must be considered. Another landmark judgment is Vikas Kumar versus UPSC 2021 Supreme Court, where a candidate with a disability requested a scribe in the UPSC exam, which UPSC denied, but the Supreme Court said reasonable accommodation is the constitutional right under Article 14 and 21. This was a landmark win for differently abled student. You can mention another case also, that is Modern Dental College versus State of Madhya Pradesh 2016, where the court upheld state right to regulate entrance exams in private colleges, ensuring transparency and the preventing profiteering. These cases show that Supreme Court act as the guardian of student rights, making sure exams are not just about marks but about justice and fairness. Let's move on to the another important aspect, balancing merit versus social justice. The one of the biggest debate in exams is merit versus reservation debate. Critics say reservation dilute the merit, but the Supreme Court repeatedly have clarified that merit cannot be only exam scores. True merit consider the background of students, opportunities, social disadvantages, and access to resources. For example, a student scoring 85% in a rural government school without coaching may actually show more merit than a student scoring 90% with urban facilities. Likewise, the court, though in Indra Sahane and EWS reservation judgments, have emphasized the substantive equality, that is, equality of opportunity and not just the equality of treatment. So, exams in India are not just about mark sheets, they are about ensuring that no one is left behind. Let's move on to the next part of the session, that is regarding the current issues and the challenges. Even today, exams equality is under scanner. Under challenge, some major issues are language barriers. Exams like NEET were earlier only in English and Hindi, leaving out regional students. The court had to push for the more regional languages. Next point is that is digital divide. During the COVID-19, many students lacked access to online classes while exams continued. Courts intervened in postponement cases. Another challenge is cheating and the paper leaks. These compromise equality and the fairness. Courts have ordered re-exams in some cases to ensure justice. Another is excessive coaching culture. Students with money get advantages while poor students are left behind. Court encourages state policies to bridge the gap. So while the court has been active, the journey is still incomplete. Let's move on to the last part of this session, that is the conclusion part. So what do we learn from the today's session? First one, the Supreme Court is not just a legal body, it is the protector of fairness in education. Secondly, by using Article 14, 15 and 21, the court ensures that exam remain a tool for opportunity and not discrimination. Thirdly, though judgments on reservation, NEET, UPSC, rights of disabled students, the court had built a framework where justice and merit walk hand in hand. But challenges still remain. Inequality in resources, digital divides, language issues all need constant monitoring. In the end, equality in exams is not just about writing the answer or writing in some paper. It's about making sure every student has the same chance to succeed. That's the real meaning of exam equality under the Constitution. Likewise, this video also, if you belong to a student who is not comfortable in English, you can easily open the subtitles in your preferred language. Before we close, let me ask one last question to you. Do you think India's exams are truly equal today, or are we still tilted in favor of the privileged classes? Share your views in the comment below. Your perspective matters. And if this video gave you clarity, don't forget to like, share and subscribe for more powerful legal insights. Remember, the exam hall is not just about marks, it is also about justice, dignity and opportunity. And as long as the Supreme Court stands, equality in exams will always have a guardian. See you in the next session. Until then, keep learning, keep questioning and keep believing in the Constitution. And if you want to study personally with us for your judiciary and APO examination, you can enroll in our courses from our website Doon Law Mentor and our app Doon Law Mentor. Jai Hind. See you in the next session. Thank you.